presiding. All persons having business before the board is drawn near to give attention for God save the United States of America, state of Florida, and this honorable court. Please remain standing for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated.
Thank you, Marshall Crawford. Good morning and welcome to the oral argument session of the 6th District Court of Appeal. I'm Judge Keith White and I have the honor of presiding today. Serving with me today on my right is Judge Jared Smith, and to my left is Judge Wayne Wooten. And Judge Wooten is an associate judge serving with us today. He normally serves as a Ninth Circuit judge in the Ninth Judicial Circuit for the state of Florida, Orange and Osceola counties. Want just to remind everyone that this oral argument session is being both video recorded and audio recorded. It's also, I believe, being broadcast live on YouTube. So just be aware of that. And then also, if you could please make sure that your phones or other electronic devices are on silence and not vibrating during the proceedings, that would be appreciated. All right, we do have one case on the docket today, and that is the case 2023, 6D232623, Discovery at Home LLC versus Aid and Allied Companion Care Service LLC and Alicia Carrington. So at this point, Appellant's counsel, are you ready to proceed? Appellee's counsel, you're ready to proceed. All right. Please proceed. On counsel, I'm sorry, before you start, if you could just let me know whether how much time you'd like to reserve for rebuttal.
5 minutes, Your Honor, if that is acceptable.
That is acceptable. Thank you.
Good morning, Your Honor, collectively, and may it please the court. My name is Michelle Diaz of the law firm Quinteros, Pietro, Wood & Boyer. I represent the appellant Discovery at Home LLC. We have asserted this appeal of the trial court's non-final order denying the appellant's motion seeking temporary injunctive relief against the appellees Alicia Carrington and Aid and Allied Companion Care Services. This case concerns a non-solicitation agreement. We have argued that the court below has committed error by disregarding and misapplying the applicable law to the facts that were presented at the injunction hearing, both testimony and evidentiary and documentary evidence, by denying injunctive relief, and that the appellant has established a likelihood of success on the merits and that it has no other available remedy at law and that its holding should be reversed. If Your Honors would allow, I would like to just start with a brief introduction of the parties and facts at issue. My client is
Counsel, I believe we're familiar
Yes?
with the facts. We have read
Okay,
the briefing,
great.
but thank you.
Perfect. Okay. We have argued the following errors, Your Honor, and I guess I'll start there. Is that Ms. Carrington was subject to that she signed a non-solicitation agreement in connection with her employment with Discovery at Home, which is part of a conglomerate, for lack of a better word, with its sister company, Discovery Living, who was its sister company at the time, is now their parent company. And the way these
Counsel, if I could just pause real quick.
Sure.
So just while you're talking about signing the non-solicitation agreement, what I see in the record is I see a click wrap agreement where somebody clicked an I agree in relation to the employee handbook. I have looked at the cases that you've cited, the click wrap cases, and I'm not going to repeat them. They're in your brief. Did you have any cases where there was a click wrap agreement, like an employee handbook or whatever other document, that had separate attachments at the end of it, each of which required a signature, have their own separate signature lines? Do you have any case law that says just by saying, I agree, I read the employee handbook, that agreement imputes a signature to every document that's attached to the handbook?
Your Honor, I would say that the signature page itself references the actual non-solicitation provisions that are in the handbook and actually
Does it?
rephrases them.
Why don't you, well, let's look
Yes.
at it.
Yes.
Let's look at that, because I think that is, what you just said is very important. Because if it did, then it would probably answer my question. But when I look at the actual language, which is on page 473 to 474 of the record, all I see is that the click wrap portion where she clicks I agree references the confidentiality portion of the agreement, but it does not reference the non-solicitation portion, which is the portion that says that you can't service former clients. So do you, tell me if I'm reading this wrong, counsel, but I don't see anything in the click wrap, the actual language where she said I agree, that references non-solicitation, as you just said.
So, Your Honor, may I grab the non-solicitation behind me?
You may.
Is that okay? Okay. You are correct, Your Honor, that the bottom of the page, which does reference the entire signature page, is one and the same connected to the handbook, because in order this is in order to
Well, that
click
wasn't my
this.
question, though.
Right.
My
So
question was, are you aware of any case law that says when you agree to something like an employee handbook, and we can come up with numerous examples, but we'll just use employee handbook because that's what's here. When you have separate documents, as your employment handbook does, multiple separate documents, each of which have their own signature line, that just by saying, I agree, I've read this employee handbook, that imputes a signature on every attachment to the handbook. Do you have any case law that says an I agree click constitutes multiple signatures and not just one signature?
Your Honor, I believe the case law that I have just constitutes that a click wrap agreement is valid under Florida, and this constitutes one agreement, including the agreement should encompass its attachments, and it does
Well,
reference the
that's,
handbook.
I mean, I appreciate
Yeah.
you saying it should
It does.
It should,
Mhm.
and I appreciate you saying that it does. My question isn't what your opinion is. My question is, do you know of any case law that supports what your opinion is before this court?
Your Honor, the case law doesn't specify between attachments and contracts, but just a contract itself. And the signature page on the bottom, and where it says proprietary information and confidentiality agreement, is referencing what the confidential information is and what it means and who those
I'm not
clients
disagreeing
are.
about confidential information. I agree that that's there. And I think that you would concede before the court that the cases that you've cited, none of which have an attachment scenario like we have here. Is that correct? Are you aware? Tell me now. Are you aware of any of the cases that
They
you cited
don't
that have attachments?
They don't specifically reference separate attachments, but they don't specifically say that separate attachments would constitute something different other than than the contract that's being acknowledged, read, and signed by clicking agree, downloading, and signing the agreement. There's no separation in the case law to indicate that there's actually a requirement for an attachment that's referenced and attached to the contract. So I'm sorry if I'm not answering your question, but
No, you answered it. I mean, it sounds to me like your answer is no, you're not aware of any specific case law, but you would like the case law to mean that the attachments are included. And that's fine. I don't want to
No.
hang you up. I know that other
No.
judges have more questions. So
Of
why
course.
don't you move on at this point, counsel? Yes,
Okay.
you have answered my question.
okay, thank you. Okay. So
Counsel, I'm sorry, before
Yes.
you move to your next point, while we're talking about this attachment, I looked at the appendix and I did see that this, the documents that your client asserts are the agreement are attached as an exhibit to the complaint. However, from my review of the transcript, there was an exhibit, an actual exhibit admitted into evidence at the hearing, which from the colloquy that's in the transcript appears to be some sort of agreement for what your client was alleging, claiming was an agreement. But I didn't actually see the exhibit that was entered into evidence as part of the appendix. Am I correct, or did I miss something?
I'm not exactly certain what exhibit you're referring to. I have
At
was
the
admitted
hear-
into
at the
evidence.
hearing,
Yeah.
there was an evidentiary hearing before
Yes.
the trial court, correct?
Yes.
And wasn't what your client purported to be the alleged agreement upon which its claim is based, wasn't that offered and accepted, admitted in evidence as Exhibit 1?
Yes, Your Honor, and that starts in page 409 of the appendix, which is the Discovery at Home Handbook, which ends with the signature page.
I didn't see an exhibit tag on that. That appeared to be Exhibit 1 to your client's complaint, which there's nothing wrong with that. That's required by the rules of pleading. You attach the copy of the contract under the rules of pleading. But we're reviewing the trial court's decision after an evidentiary hearing at which the trial court accepted and considered and based this order on an Exhibit 1 in evidence, and I don't believe that I have that.
It's
Is that correct?
It's the same exhibit, Your Honor, the handbook exhibit, which is Exhibit 1.
And how would I know that
Um,
if I can't see what the trial court saw?
I have no other exhibit and there was no other contract ever produced or existed under the record other than we actually admitted it into evidence as Exhibit 1, which is actually,
The
right.
record reflects that something was admitted into evidence as Exhibit 1. It could have been one page, it could have been 100,000 pages. How do we know what the trial court based the order on?
I used the exhibit to the complaint or the motion for temporary injunction as the same exhibit. Just took it from that document during the hearing and used it during the hearing as part, and I believe that it's referenced as an exhibit to that document that was already in the record.
Okay. Thank you.
You're welcome. Okay, so we argued that there were restrictive covenants under this employment arrangement, that the appellee was the face of this company, that she was in direct communication with all clients or prospective residents of the building, which all prospective residents of the building were considered to be prospective residents of my client, which my client only services the buildings of its sister company at the time as the main, not only because obviously there are rules that would prevent monopolizing these type of facilities, but given that it was its sister company, this person was trained and hired, as we established below, to be the face for all residents constituting prospective clients coming out of that facility. We also argued that my client had a legitimate business interest to protect. And I can go through the specific pages in the record where my client specifies that. For example, they trained Ms. Currington in methods to cultivate those relationships as a cookbook for being able to service not only the clients that were already in their systems, but also residents of that building, and that's in page 60 of the record.
Counsel, I'm going
yes.
to just ask you this because it's related to what you just said about Ms. Currington and her potential use of confidential information. In your initial brief, pages 33 to 34, you state, Currington herself admitted in her testimony that she based the pricing of AA, which is Aid and Allied, on Discovery's pricing. And then you quote a portion of the record, and then you conclude from that, as apparent from above, Currington has indisputably utilized Discovery's confidential information. The quote that you put into your brief says, this is a quote from Currington. She says, I didn't use their model. That's what she said. And your characterization of that is that that's her admission that she did use it, even though you're quoting a portion where she says she didn't use it. I'm a little confused about that, counsel.
Sure, Your Honor. So where I derive that argument from is from page 251 in the record, where the question was, so your prices were less than DHS was offering, is that correct? And other competitors, yes, that was her response. She also admits right under that she had access to their pricing model. So she saw the pricing model, set her prices lower than the pricing model, and use her pricing model in her own pricing for her new clients in her new company.
This is definitely one thing I would counsel you on in future briefs to the court. Cite the portions of the record that are supportive of what you're saying, not the portions that go the opposite direction of what you're saying. What you just provided was a portion that seems to support what you're saying. What is here in front of me is what you cited in your brief, where she said, I didn't use their model. So there are numerous instances, and I'm not going to outline them in your brief, where you make these broad sweeping statements and you give no cite back to the record. And again, I don't want to take up your next 6 minutes talking to you about it, but I'd ask you to take a look at your brief and review it, and just ensure when you're submitting briefs to the court that you don't put your opinion of what the facts say, that you actually put cites back to the record. Because I would look through the entire statement of facts that you did, and then I looked at your arguments, and there were multiple arguments that you made that just didn't have any citations to the record. I went through the record and I found, I think, what you were referring to sometimes. I don't know that I necessarily would say that just because her pricing is lower, that necessarily means that she's admitted to using the pricing model. It just means that she's got lower prices. It could just be that who's to say that your client doesn't have a high price and her price is more at a normal price range? We don't know that. To even say from that that's an indisputable admission that she's using it when she says she didn't use it. I think I would be more careful with the way you're characterizing the record. How you just said it, Judge, she's told the court, she said that her prices were lower. Say that. Don't say that she's indisputably admitted to using confidential information in her pricing system. She didn't. You asked the question, where are your prices compared to the ones that she had? She can't get out of her mind whatever your pricing structure was. Short of a memory ray gun, I was thinking maybe Men in Black. Short of a memory ray gun to erase her mind, she knows what you all charged. You didn't have a non-compete clause. You had a non-solicitation clause and a non-confidentiality clause. Had you had a non-compete clause, I think that would have solved your problem. That's not what you had here. So in any case, I'll stop there, but I would just counsel you in future briefs to the court to ensure that your statements are supported by record cites. Okay.
Thank you, Your Honor. We also argued that we had a legitimate business interest to protect, that the restrictions were reasonable.
Counsel,
Yes.
where in the trial court's order did the trial court make a finding that your client had proved the existence of one of the enumerated legitimate business interests that the legislature has said have to exist in order for a restrictive covenant to be enforced?
I'm sorry, can you repeat that, Your Honor?
Where did the trial court, in the statute, section 542.335, sub 1, sub B, it says the person seeking enforcement shall plead and prove the existence of one or more legitimate business interests justifying the restrictive covenant, and then enumerates 1, 2, 3, 4. 4 has A, B, and C, and then 5. So where in the trial court's order did the trial court find that your client proved the existence of one or more of those business interests?
The trial court did not find that. I mean, that's part of the reason why we are here. However, several of the witnesses that the court found to be credible, including Mr. Cundiff's testimony, was disregarded by the court that laid out the legitimate business interests that we were seeking to protect. So there's contradiction in the record in the order where several of the witnesses that support a finding of a legitimate business interest and an injunction.
Could you point me to what is you believe inconsistent?
Sure. So number 2 in the order, and I'm citing from page 27 of the record, Your Honor. The court finds that Dan Cundiff to be a credible witness, except these are the issues that, he claims that there was insufficient testimony regarding the income drop that occurred when Ms. Currington left and opened up her own company
Well, I'd like to
was
get
not.
to that issue. That's the
Sure.
issue I've been waiting to talk about. So number one, there was a document purporting to show the income stream over the course of the year. It was apparently admitted in evidence, but it is missing from the actual record. So now we're limited to the actual testimony about that document. My questions are as follows. It's clear from Mr. Cundiff's testimony that the revenue drop started prior to Ms. Currington departing the company. Is that a fair statement?
Shortly before, yes, Your Honor.
Also, while he talked about gross revenue, he didn't talk about how many clients they had. And I think this is important because later on you offer 4 residents of the building that Ms. Currington now had a relationship with, although 2 of them were referred by the sister company to Ms. Currington. But Mr. Cundiff also talked about this being a wildly competitive field. So how do we know how much revenue was lost to Ms. Currington? How did the trial judge know how much revenue was lost to Ms. Currington versus some other entity that also was lowballing their prices or going lower than Discovery at Home?
Discovery, to answer your question, and then I'll explain, there was no differentiation between, what clients, other clients, like you mentioned, that could have come from other companies or competitors. However, what it did show was that once Ms. Currington opened up her own company, or even right before, so in other words, after the time frame that she asked for a demotion from being the business leader of several facilities, to just this one particular facility being her main hub, this is when we start to see a decline in revenue. And then when she leaves and opens up her own company, all the way to 0. And the testimony and the documents were specifically tailored to companion care services, not, the Medicare Part A services, completely in connection with the services that she was trained to provide for this facility and that she did provide for this facility, to the point where we were forced out of that facility due to her, being the competition. She was the main person in this building. Every single referral that came through Discovery Living was filtered through her, not through anyone other than her. And so all of the income was always derived as a result of her services as our employee, and then declined as a result of her no longer being our employee and implementing the training and the services and, the services through her own company that she learned from, and she had access and had the privilege of being part of this, halo or conglomerate type model.
Thank you, counsel.
Thank you, counsel.
Is my time up? Okay.
Yeah, you still have your rebuttal time.
Okay, thank you,
And
Your Honor.
responding to Judge Wooten's question won't go into your rebuttal time. You'll have a full 5 minutes.
Thank you so much.
Counsel?
May it please the court. Attorney Christy Scott on behalf of Aid and Allied Companion Care Service LLC and Alicia Currington. Your Honors, I am here today asking you to find that the lower court tribunal findings of fact were supported by competent, substantial evidence, that the findings were not an abuse of the lower court's discretion, and its conclusions and reasoning in this matter were proper and just. Your Honors, being familiar with the facts, you understand that Discovery at Home and Discovery Senior Living are 2 completely separate entities. Being familiar with the facts, you understand that Ms. Currington came to Discovery at Home with years of experience that allowed her to decide to start her own business and to price her services based on what she thought was fair and reasonable. Understanding the facts of this case, you are familiar that with every single person that opposing counsel alleged that was solicited, we called them in to testify, either themselves or their family members. And each and every one of them stated that they were not solicited by Ms. Currington. And so for all of those reasons, and based on the high, very high abuse of discretion standard, the court made a very detailed finding, detailed findings of fact, finding that temporary injunction was not appropriate. And so for those reasons, we respectfully are here and available to answer any questions that you have, but we believe that the lower court's ruling should stand, Your Honors.
Counsel, with respect to the abuse of discretion, is that the standard of review that we apply? If we take the trial court's findings of fact as established
Mhm.
and find, yes, they're supported by competent substantial evidence, if we reach that conclusion, then is the standard still abuse of discretion when we compare those findings and applying the statute to those findings to determine whether the appellant was entitled to a temporary injunction?
Your Honors, I believe that as it relates to the abuse of discretion standard, that it should be applied as it relates to the factual findings. However, if it's something based on the law, based on my research, I believe that it would be a lower de novo standard. And so if it's something that specifically in applying the fact to the law, the written statute dealing with restrictive covenants, I think that would be a lower standard. However, here, I think that Discovery at Home failed to meet their burden in nearly every respect. I believe that they failed to meet their burden, that there was a contract that was signed. I believe that they failed to meet their burden that she was soliciting. And so for all of those reasons, I think that the court had a very specific, factual, heavy order denying their motion for temporary injunction. And I think that this is not necessarily something that is based on how it's applied to the statute. I think that it's based on findings of fact that they just essentially failed to prove their case.
All right, thank you.
Counsel, I had a couple questions. First off, just getting back to the hearing itself, I'm going to pull on your memory here because the record is unclear on this point. It seems that you all submitted your evidence, submitted your testimony, and then I see a portion of the record where the trial court does what I used to do, which is, okay, let me have a chance to look at all this. And it appears that the trial court stayed on the bench while he was looking through all the documents, and then made a ruling at some point. But what's not clear in the record, sometimes court reporters will say 5-minute break or whatever, but there's nothing that really reflects how long the court was going through your papers and going through the court's notes. Do you recall approximately how long that the court sat there and flipped through notes?
I can give an approximate based on my memory. If I recall correctly, it was about 5 to 10 minutes. And what I will say is it was a very long hearing. We were there for about 7 hours. Throughout the hearing, the judge took notes. And then once all of the evidence had been presented, the judge sat there on the bench and flipped through various documents. Obviously, we're unable to see exactly what the judge was looking at. But if I had to give an estimate, 5 to 10 minutes, and then the judge started to rule. And as the judge ruled, the judge went through each and every witness and went through whether he found that witness to be credible and what he found that witness to be credible as to, and spoke to it, likely reviewing his notes as he did so.
Thank you. My other question relates to the non-solicitation clause. And I understand that your position is that it was that the court ruled that didn't rule, I guess, effectively. So therefore, we don't have a ruling, and therefore we assume maybe the court could assume either way. That the court either found the non-solicitation clause was enforceable, was a signed agreement, or was not a signed agreement. I already asked your opposing counsel multiple questions about the case law and whether there was specific case law on attachments. I would ask you the same question. Did you find any case law that related specifically to attachments when somebody does a click wrap?
No, I am
And
not.
that's fine. I didn't find any either. I really wasn't. I gave, it's her, she's the one appealing it, so I gave her an opportunity to present that. The follow-up question I have to that is, in relation to that non-solicitation agreement, let's say that we go with your opposing counsel's position, which is that somehow implicitly, because of the way the court worded their ruling, that the court did find that the agreement was enforceable. Okay. I'm not saying that I'm going that way. I'm not saying I'm not going that way, but that is their position. Let's say that it was found to be enforceable, including that attachment that talks about non-solicitation, which does have a provision in there that says that she, Mrs. Cunningham, is not supposed to solicit anyone that's a client at the time of her termination. And she's not just not to solicit them, it says she's not to perform services for them. What is your position in relation to whether she violated that very narrow slice of providing services for someone who was a Discovery at-Home client at the time of her termination?
Essentially, it's our position that even if you found that the contract was properly signed and attached, that there was no evidence of even one client that was solicited, and that the terms, like prospective clients, were not defined. And so there was no finding that, because I think that we have to take the trial court's findings essentially to be true, but there was essentially no evidence whatsoever that there was any clients that were solicited, and there was no definition as to what a prospective client was.
And you understand, the solicitation is not where I'm focused right now. I'm focused more on they call it a solicitation clause, but then they put this provision in there that says that she can't provide services for.
Understood.
So I'm not so much focused on the solicitation. I'm focused on, is it your position that there's nothing in the record that says that there was any clients of Discovery at Home at the time that Ms. Cunningham was terminated, or not terminated, I use the word terminated, that's improper, at the time that she left her employment with Discovery at Home, that there are no clients that she was subsequently servicing in her new company, Aid and Allied?
I want to fact check myself. Just give me one moment, if you would. It's my understanding that there were clients of Discovery Senior Living that were serviced, but Discovery Senior Living is a completely separate company than Discovery at Home. It's also my recollection that Discovery Senior Living, different company, referred Ms. Currington to several clients. And then it's my understanding that there was one person that was serviced, but that their family member testified that she had never heard of the company. She didn't realize that Discovery at Home had ever serviced that person. And so there's not any, there was no indication that Ms. Currington had done something wrong, because not even the family member knew that that person had ever been serviced by Discovery at Home. That's to the best of my recollection.
Yeah, I understand, counsel. That was my read of the record. I found maybe one person that might fit that category out of all the testimony that was presented. Okay, thank you.
In order to continue with my argument, I would like to talk a little bit more about the ability that the trial court has to weigh the evidence, and specifically the truth or falsity of the testimony of various witnesses, the effect thereof, and the weight to be given to the testimony of each witness are matters for the triers of fact to determine, and not an appellate court. In this situation, you have an issue with the actual agreement, whether it was signed. As you all are aware, we submitted evidence to show that this was simply a click wrap agreement, that the actual document doesn't refer to solicitation. that the employment agreement actually had language in it that said that this is not a contract, as is often language in employment handbooks. And then also that the time in which opposing counsel indicates that the contract was signed was not even a time that Ms. Currington was at work. And so Ms. Currington testified that she did not sign the agreement. There was no audit trail or anything of that sort to indicate that the agreement was signed. And so I think that there is an issue from the very start as to whether this was a signed agreement. And the court did not rule that this was a signed agreement, which I think would be a requirement. And then further, I'm going.
Did the trial court rule there was not a signed agreement?
No, the trial court was silent on that issue, and there was competing evidence, but again, no audit trail, no actual signed agreement is in the record. The only thing that we have is that click wrap document, and so.
So how does that affect our analysis?
Well,
Isn't the very first item that the legislature has established as far as the requirements of a restricted covenant is that it's got to be a writing signed by the person against enforcement assault is sought?
Well, it would be my opinion that because we don't have that determination, that the appellant essentially fails, that the temporary injunction cannot be granted without that written signed agreement, which I don't think that we have here. And then further, to go to the other rulings from the court, I believe that the other elements also fell. Specifically, the court did find that there was competent evidence that she did not use, when I say she, Ms. Currington did not use or abuse confidential information, that she came to discovery at home with years of experience. There is competent evidence that the contract itself had to be construed against the drafter, that being discovery at home, the fact that it did have language to indicate that it was not a contract, the fact that it did have references to discovery at home and then references to this other company, Discovery Senior Living, that Ms. Currington never worked for, that there is competent evidence that Ms. Currington is only involved in companion care services and that Discovery at Home provides medical services. And to that end, in the appellant's corrected initial brief, they talk about the training and confidential information that they gave to Ms. Currington, and they specifically indicate that it was related to medical services and medical care, none of which she is, Ms.
Where are you
Currington is
finding that
using.
in the record?
So if you were to, well, I'm referring to their initial brief.
Okay.
And specifically, give me 1 second. It is actually in their, it's in their statement of the case and facts. And I'm looking for exactly where it is. My apologies. Okay, here it is. Actually, it's not in the statement of facts. It's on page 6 where it talks about Discovery's operations. And it says that Discovery is a home health business providing a variety of services to clients in Florida. That it talks, it goes into the Medicare line of business, which is a reimbursed skilled care, and then private duty companion services. But then it also goes into I believe it also goes into the medical services. I'm just trying to get to that part. Oh, here it is, page 11. it says Currington received highly specialized on-the-job training regarding the discoveries, medical-related techniques and processes, medical systems. Then it says management, logistics, operational processes, and the overall know-how that has led to discovery success. But being that this is a home health company and that is indicating that the highly specialized on-the-job training that Ms. Currington received was related to medical services, I believe that that's very different from the companion care services that she provides through Aid and Allied Companion Care Service.
I understand they said that in their brief, but where does that, where do you think that's actually in the testimony that the judge heard, that her training was limited to medical services?
Well, I think that it also was at least referred to in the can I get my computer?
Sure.
I think that it was also referred to order of the court. So specifically, if you were to look at section 2C of the order denying the temporary injunction, it says that under Dan Cundiff's testimony was that Alicia Currington's business was a subset of companion care as opposed to the home health care skill services provided by plaintiff. And then there was not, it may not have, I'm just kind of trying to remember. I think that's the only section that actually references specifically the type of training that she received. But under section 9, it says the court found that there were several confusing issues. And one of those issues was 9B, many services that plaintiff provides are skill services regarding Medicare, Medicaid, long-term insurance, and self-pay that cannot be provided by the defendants. And so I think that the court did make a finding that it was at least confusing as to the difference in services and whether that was somehow a violation of the agreement.
Thank you.
With that being said, I do believe that the trial court made the appropriate decision. I think that it was a guided decision based on 7 hours of testimony. I think that it was very specific and factual. And I believe based on case law that was cited in our answer brief, that the appellate court's responsibility is to take those findings of fact as true. And for those reasons, we would ask that the appeal be denied.
Thank you. I apologize, counsel. I'm trying to. All right, counsel, I think I figured it out. Apologize. above my pay grade.
Thank you, Your Honor. I would just like to briefly rebut a couple of issues that my colleague has mentioned. First is that Ms. Currington testified that she knew that these companies were sister companies. This was on page 275 of the record. She was not just going into some random building providing companion care services, but specifically trained to be the face of Discovery at Home for Discovery Living's facility. So much so, related companies that today they're one company.
Where did the trial court make that finding?
The trial court did not, the finding that the companies were sister companies or that,
Where did the trial court make a finding based on the evidence that your client, Discovery at Home, could enforce a contract in the name of Discovery Senior Living? Oh, and Oasis, a Paychex company.
there is no finding of that. And my client was not trying to enforce a Discovery Living contract. There is on the signature page, there is what appears to be a reference to Discovery Living, and what was explained in the testimony at the hearing was that they use Oasis, both companies use Oasis for their onboarding. And so, and I'm paraphrasing for Your Honor, apparently it seems that Oasis provided this document naming Discovery Living within the text, but that same document, which is the signature page, refers on multiple occasions throughout the document to Discovery at Home and referencing specifically that she's agreeing and understanding to the terms that are found in Discovery at Home's handbook. My
But
statement.
counsel, if I can.
Yes.
I'm looking at, and this is page 473 of the appendix. It says the following confirms an agreement between Ms. Currington and Discovery Senior Living, hereinafter referred to as the company, which is a material part of the consideration for team members' employment or continued employment by the company, meaning Discovery Senior Living, and then lays out what you're contending is an agreement. And so my question is, if we implicitly infer that the court found that this was in fact signed by Ms. Currington, how can we conclude that the trial court, by other language in the order, didn't find, to the extent this was an agreement, it was between Discovery Senior Living and Ms. Currington, and Discovery Senior Living is not asking me for an injunction. Your client, Discovery at Home, is asking for an injunction.
Yes, Your Honor. And so I would refer to, and this is actually in my opponent's brief of the Columbia case, which is the first DCA 127 Southern 3rd 670, which holds that a court's interpretation of a contract is a matter of law, but also that the contract has to be taken as a whole in all considerations when being interpreted by the court. And what I would refer, Your Honor, to is that at the beginning of this page, first, she was not, there's testimony in the record that that they were sister companies, but they don't employ the same employees, that she was not an employee of Discovery Living, but of Discovery at Home, that she testified that she understood that she was an employee of Discovery at Home. She testified that she read the non-solicitation, that she understood the non-solicitation. She never testified that she didn't actually sign the agreement, but that she did not recall signing the electronic agreement. There was testimony in the record that she was seen signing the onboarding documents. The document itself refers to the handbook. And yes, I concede that the bottom of this page says Discovery Living, but the entire document and all of its, the rest of its pages and its exhibits refer to Discovery at Home. And she was well aware that she was bound by the restrictions of Discovery at Home, which includes a non-solicitation provision and confidentiality restrictions. Your Honor, sir, I would ask that the contract be taken in the proper context given the language of the entire contract and the testimony that was presented before the trial court.
I know your time is up, but I just have one last area of inquiry. I do real quickly just would ask, same question that I asked your opposing counsel. What would you say that time frame was that the court finished up the evidentiary hearing and took all the testimony? How long was the court on the bench flipping through his notes and whatever else you provided him before he made the decision?
It was about 5 to 10 minutes.
Okay, so you would agree with your
Yes.
opposing counsel?
Yes, Your Honor.
In your initial brief, you state, this is on page 4, so toward the beginning, you say the trial court hurriedly issued its ruling in camera after nearly a 7-hour-long hearing. And first off, I didn't really understand. What did you mean by the trial court ruled in camera?
I meant at the hearing, during the hearing, rather than
I mean, typically
after.
in camera would be like in chambers. So, all right. But more importantly, I would say 5 to 10 minutes. I understand that when you don't get a ruling that you want, there's always going to be a frustration saying, man, I wish the court would have taken a little bit longer. But as the court actually stated on the record, which is true with most judges in the state of Florida, we have thousands, especially as trial judges, we have thousands of cases anytime sitting on our docket. So to say 5 to 10 minutes of reviewing notes, reviewing your exhibits, which really weren't that many exhibits, and the issues weren't overly complicated in this case, you wanted an injunction and the court said you don't meet the 4 factors for an injunction. Most people, I would say, they appreciate a court getting to something right away as opposed to having to wait, 2 or 3 weeks or 2 or 3 months for the court to issue a decision. So I once again would counsel you to be careful throwing this out in almost a disparaging way toward the trial court, hurriedly issuing its ruling, when in reality, the court listened to all your testimony, gave you 7 hours worth of hearing time, took 5 to 10 minutes to look over the notes. Some decisions are easier to make than others. And there are many times that we can make decisions rather quickly, and they're absolutely fine decisions or maybe wrong decisions. We could take months and still make the wrong decision. So that really was the area that I wanted to inquire about, just something I wanted to talk to you about. The big picture question that I did want to ask you is, in a really large frame, 10,000 foot overview, your allegation in this case is that Ms. Currington effectively stole clients from Discovery at Home, that she solicited them inappropriately and serviced clients inappropriately in breach of your agreement. And my challenge with that is that the record reflects that your clients gave her the clients. So we've got Nicole Kaufman, who was the resident services director of Discovery Senior Living, a 4-year employee. Ms. Currington had only worked there for like 9 months. She's a 4-year employee. And she says she gave her all of these referrals, knowingly gave her referrals to Allied, Bob, and Geraldine, and all these people that you're saying that she stole. Your people gave them to her. And then I didn't even talk about Mr. Peter Hendrickson, which is your Discovery Living campus executive director. He's the campus executive director. And he says he referred people to Ms. Currington. He referred them knowing that she was a separate company because she did a, quote, great job from what he could hear from the residents. And when asked, both Ms. Kaufman and Mr. Hendrickson, when they were asked the question, did she ever ask you to send her referrals? They said no, unequivocally no. So putting this in the best analogy I could come up with, and it's probably pretty weak, if you have a lawn service and your lawn is supposed to be serviced 4 times a month, and you've got a contract with your lawn service guy to do that, and you tell your lawn service guy, don't come this Saturday, I've got something going on at the house, you can skip this week. And they skip that week. Can you sue your lawn service guy for breach of contract for not coming that week? But that's a legitimate question, because it's a bit of a setup, but I Could you imagine any circumstance where you could sue your lawn service guy for breach of contract when you yourself told him, don't mow my lawn this Saturday?
No, but I think that's different than what actually occurred
Okay,
here.
so let's then translate that to this.
Yeah.
You have a contract that says don't solicit clients, don't service clients, and then you, Discovery Living, give her clients, refer her clients because you think she's doing a good job. And as Ms. Kaufman said, and I think this is pretty powerful testimony, she said, well, you know, Discovery Living can't take everything. There's a lot of times they just couldn't fill the requirements. That's the record 203 to 204. So how can we say that there's really no way the trial court got this one wrong when you all were inducing the breach of contract? If I find everything in your favor, I still have to find, based on these facts, you all induced this breach of contract. Tell me that I'm wrong about that.
Your Honor, respectfully, I would have to say that that's incorrect because we are not Discovery Living. We are Discovery at Home. Yes, they are related in the fact that they share ownership, but they're two separate entities. And it was very clear that we were the primary source of company that would provide companion care services in that facility, but we were not one and the same. Today we are, but this postdates everything that occurred here. Discovery Living employees are completely separate. They would refer all business to her, Ms. Currington, whether or not knowing and believing that she was our representative, Discovery at Home.
Well,
Yes, later she did
Counsel, I would
provide.
completely disagree with you. I think the facts are 100% that they knew. Ms. Kaufman said, I was going to give it to Aid and Allied.
Yes.
Mr. Hendrick's testimony is 100% he was giving it to Aid and Allied. So I think trying to paint it as though they were giving it to somebody else, there's faint evidence in the record that would support that.
No,
the majority of this record is that they knew she was Aid and Allied.
Yes,
So-
and I agree with that.
So your defense to that is that they're two separate entities, Discovery Senior Living versus Discovery at Home. It wasn't Discovery at Home that gave her these clients, it was Discovery Senior Living giving her clients. That would be your defense.
When she opened up her own company, they chose to give her clients. That is true, and they have a right to do that. However, the residents of this building, she knew, were prospective clients of Discovery at Home, which she was trained to solicit while being an employee of Discovery at Home. She had an obligation to reject these referrals under her non-solicitation restrictions, regardless of whether they wanted to give it to her or not. I never have I represented that.
So our
Yeah.
lawn guy, when you tell him don't mow your lawn, he has an obligation to mow your lawn anyway?
I am not the
Because
same
it's under his
person.
contract?
These are two separate entities, two separate
well,
obligations.
I mean, at one point you were arguing that they're one and the same when Judge White was asking about whether the contract is enforceable against Discovery Senior Living, and you said, well, it is because they're one and the same. And now you're saying that they're different. I would say that that's an interesting argument. I didn't think that was the tact you were going to take. I will consider that. Okay, thank you. You
I'm
definitely
sorry, Your
responded to
Honor.
my question.
And let me just correct that. What I meant, what I actually argued about the signature page and Discovery Living is that they use the same onboarding company to create their documents, but that she knew that she was an employee of Discovery at Home and not Discovery Living. And I would never disparage any judge by saying that they hurriedly made a decision. What I meant was, given that there was so much testimony that needed to be taken into consideration, and these same witnesses were deemed to be credible, we felt that 5 to 10 minutes was rushed,
Well,
but in no
counsel,
way.
if you're going to push back on that one, I will tell you that judge was sitting there. They listened to the testimony. They weren't reading this. They weren't watching a video and having to replay it multiple times. They sat there. They listened. They made their notes. They were making judgment calls as they were going through that entire day as to which witness they felt was credible and which one they weren't. If they weren't doing that, then they weren't doing their job. So typically, there's nothing wrong with the judge being ready to rule at the end of even a 7-hour hearing or even a 2 or 3 day hearing. Oftentimes, judges will say, okay, I've heard all the evidence and I know the answer is the case dismissed, injunction granted, and here's why. So yeah, I appreciate you explaining that, but I would not accept that. I know we're way over time.
Oh,
So
well, I appreciate that. I really honestly appreciate your constructive comments because they are helpful to me, and I'm grateful for that.
absolutely, counsel. Thank you.
So I did want to mention, do I have any more time?
You need to, I mean, just quickly
Yeah.
wrap up. Thank you.
Okay, that there was evidence in the record that there was at least one client, Geraldine, who was a client of Discovery at Home when she was indirectly solicited through Nicole, which Ms. Currington stated on the record that she relied on Nicole to be the one to know which clients she could or could not service, which also lends itself to the interpretation that she was aware of her restrictions. And so, Your Honor, I thank you for your time, for your comments, and I would ask that the trial court's order be overturned and that the injunction be imposed. Thank you.
Thank you.
All right. Thank you to both counsel for your arguments this morning. Appreciate that. And this session of the 6th District Court of Appeal oral argument will be in recess. Thank you.
All rise.